So we are going to be looking through legal writing in preparation for this exam, whereby we shall basically pass through what we covered in legal writing. So if you can pay attention at the end of this video, then we strongly believe that you will have a general understanding of what legal writing covers. So please consider subscribing, share, like, and comment. So writing skills using plain English. Writing is the best test of thinking. So language is something more than a tool of thought. It is a part of the process of thinking, according to answer later on. The importance of effective writing in law practice. So basically, when you are talking about legal writing, as far as legal writing is concerned, your writing must be simple, precise, and straightforward, and stay as much as you can from using legal jargons, because this is not what is taught here. So many criticisms have been levied against legal writing and lawyers and writing skills, that lawyers want to know basic grammar, and lawyers cannot say anything simply. So basically, the effect of this legal writing is impart in you skills to write simple, clear, and straightforward language that can be understood by any person. Causes of poor writing skills: one is style. Every profession needs its own symbols and codes. So basically, most lawyers use legal jargons like the onus of proof, like things like acts reus, mens rea, which are not understood by a lay person, whereas these words have an ordinary meaning. So in legal writing, we struggle as far as we can to make sure that these words are put in their ordinary meaning. So lawyers do not think clearly enough. Ignorance and apathy, stubbornness, and misrepresentation, especially in the use of legalese in documents drafted by lawyers. So most lawyers have argued that the reason why documents should have legal words is because clients cannot easily interpret them. So when I write to a client in strong words, then that basically means that you have to go and look for another lawyer to interpret for you, which at the end of the day creates business. But here in legal writing, we are basically looking at using simple, precise, and straightforward language. Professional lawyers are trained to be exhaustive, materialistic. The competitive society demands prolixity. Then legal economic lawyers made more money by writing poorly. Historical creatures of precedent, ritualistic. People must believe in the majesty of the law. Technological machines such as typewriters are responsible. Then institutional, the pressure of business is responsible. Deterministic, the way lawyers write is the best way to accomplish the law's goals. Pedagogical, lawyers never learn to write well, and culture lawyers don't need enough or know enough of their heritage to write better. And psychological, lawyers are afraid to review themselves. So basically here we are looking at causes of poor writing among lawyers. So we talked about style, that lawyers are being taught to write that way because they don't write to the common man. Then thinking, because the way you write is how you think. Ignorance, some of us don't know. Professional, we are trained to be exhaustive and back things by proof. Materialistic, the society is also very competitive. So in some way, lawyers write strong words because they want to create demand in the marketplace. So Richard Harland places the blame to poor writing primarily on the inability of lawyers to think clearly, rather than an ability to write clearly. How to improve on quality of legal writing: arrange words clearly to enhance clarity of the sentence. This means that sentences in your documents must be arranged very well, because sometimes even if the word is difficult, that means the person can read the whole of the sentence to understand it. Then tabulate to simplify. Always try as you can to simplify the words. For example, instead of talking about the onus of proof, you can talk about the burden of proof. Instead of talking about mens rea, you can talk about a guilty mind. And think about, instead of talking about acts, you can talk about an unlawful act. So just like that. Then use paragraphs or subparagraphs. Punctuate properly. Punctuation is considered as an aid to clarity, aid in interpretation and comprehension. Consider the following sentence: every owner, lessee or persons operating an industrial plant or a refinery, chemical words, SML, or other plant or works, or any other persons who discharges or throws or allows to be discharged or throws any noxious waste product, raw sewage, oil, sawdust, chemical, or other material or thing into a river, stream, or other water, any part of which is interprovincial or which flows into any interprovincial waters or into the sea, which has the effect of endangering the lives, safety, health, or comfort to the public, commits an offense. So the above sentence has many drafting imperfections apart from poor punctuation. Use one word to mean so many words, e.g. industrial waste or water bodies. Repetitive use of the word or, and the sentence is too long. So basically, in the final exam, they always give you paragraphs like these ones, and they want you to basically correct the paragraphs. So what you have to do is that you have to first identify errors, in case they are grammatical errors, punctuation errors. Then also where they are too repetitive, try to use one word to represent that, but not being as competitive as we can see above. So the errors we identified here are: one, use one word to mean so many words. Repetitive use of words should be eliminated, and the sentence is too long. But when you do all that, then we believe that the paragraph is going to become very literal. Writing skills, style, and communication. We are interested in clearly communicating our thoughts in academic writing. We are not talking about sounding intelligent, but rather getting you intelligent points across. So effective writing style depends on a combination of the following: audience, type of writing, punctuation, word choice, sentence construction, and overall presentation. So basically, when you are going to write effectively, first and foremost, you have to understand who are your audience. So if you have lawyers in your audience, that means you can speak with legalese. But you're speaking to a community which is illiterate, that means you have to be as straightforward and as simple as you can be. Then punctuation, make sure that your writing is very well punctuated, where there are commas, full stops, and any other punctuation marks. Word choice, also you have to properly choose your words. For example, if you're writing a demand letter, you shouldn't be threatening. Remember, you have your purpose is to demand money, but not threaten the other person, because when you threaten, things become very hard. Then sentence construction, as well as overall presentation. Active voice. Writing style is usually improved by using the active voice instead of the passive voice. Using the active voice leads to more concise and direct sentences. Example: passive, the truck was overloaded by the workmen. Active, the workmen overloaded the truck. The passive voice tends to hide the subject. However, there are a few instances when the passive is better, e.g. in calling attention to the patient, not the agent. He was murdered is stronger than somebody murdered him. So basically, when you're writing, you're always required to use active voice. For example, instead of saying the truck was overloaded by the workmen, it's better important to state that the workmen overloaded the truck. You begin with the subject, and you begin with the subject matter. So audience, writes will adjust their skill depending on the audience of the type of writing. A textbook differs from the novel. Conciseness. Concise writing means that one comes quickly to the point. It is avoidance of wordness and unnecessary repetition that adds nothing to meaning. Repetition, where the writer uses two words which mean the same, e.g. all our hopes and dreams were fulfilled when first and foremost I would like So basically, avoid repeating, because most of us always use words which are almost mean the same thing. Here within, here above mentioned. So always stay away from words which are repetitive. So sometimes there is use of inelegant expression, e.g., not different instead of similar, not the same instead of different, not allowed instead of prevent, and not admit instead of deny. So because what they always do, they also give you sentences in the final exam, and they want you to rewrite them. So here they have added all these errors, that means you have to proceed and you remove them, because they can give you that the person says that the people we are not different, and say that you rewrite that. So that means that the people are similar. So basically, that's how these things are used in the final exam. Punctuations, writing style is influenced by punctuation. The writer should use punctuation in a wise manner to achieve the intended effect. Also, simplicity, choice of words in writing. Use the simpler, more common words over the less words is preferable. The drafter must find the right word or the best word. However, the question is, what is right or best? Use specific and concrete words. The writer who uses vague words may leave the reader confused or bored. So always use specific words rather than vague words. For example, words like last year, write in 2024, but not last year. Until recently, write until the late 1990s, or mention the specific year. So you have to be specific in your writing. When they say that instead of saying school of law, you have to be specific and talk about which school of law are you writing to. Principles of legislative drafting. So basically, the first part we are looking at legal writing. Now we are going to look at legislative drafting. So there are 3 persons involved in the preparation of legislation: determine the legislative policy, legislative scheme, and also expression of the policy. So the formulation or automation of legislative policy is a preserve of the policy maker in Uganda, which is the parliament. So drafting the sentence, the best rule is to write short, simple sentences. The structure of the sentence is important. Big gates swing in little hinges. So the first principle to observe is that a law consists of the person on whom an obligation is imposed. So this legal drafting is like how they draft laws in parliament. So you have to be very, very keen to this, because these things rarely miss. They give you sentences and they say that we draft them in the final exam. So you have to make sure that you have understood how do you go about that. So we are saying that the first principle to observe is that a law consists of the person on whom an obligation is imposed, or whom the power or privilege is conferred. So basically, when we talk about you have to bring the person who an obligation is imposed. For example, you can say that any person who is found with a firearm, just like that. Any person found with a firearm, any person found trespassing in the national park, what is the required to be done or not to be done? So basically, there you should not trespass in the national park, or should not have a firearm with no valid license. The circumstances where appropriate under which it's intended the law should operate. Circumstances now becomes where you are found in the national park and you're hunting animals. The conditions where appropriate, subject to which an act may or may not be done, or shall not be done. So that means if you're found with a firearm but you have a valid license, that one is not going to apply. But basically, this part of legislative drafting, if you have read the Penal Code Act and maybe like criminal law, how basically they draft their provisions, then it's going to be good for you. But these things are always examined. The legal subjects, the subject of the sentence is a noun or an equivalent of a noun. In a legislative sentence, it is the person on whom an obligation is imposed, or on whom a power, privilege, or right is conferred. So the subject of a legislative sentence is often referred to as a legal subject, which or who need not be a person. E.g., this act may be cited as the following: two or more persons may form the legal subject. One, the managing director or the secretary of the company, a director and a nurse. So basically, two or more can form the subject of the legislative offense. The predicate of a grammar sentence is what is said about the person or thing forming the subject of a sentence. It is the same with the legislative sentence. It contains the enacting verb of the legislative sentence and determines what is required of the subject of the sentence. The predicate in a legislative sentence is often referred to as a legal action. E.g., a police officer may, without a warrant, arrest a person whom the police officer suspects of having committed an offense. Two or more verbs may be used. E.g., an appellant A may, within 14 days of delivery of the judgment of the court, file a notice of appeal, shall serve a copy of the notice of appeal to the respondent. So that's what we are supposed to do. So basically, these things you have to understand them, because like they have told you, they come in exams and they say redraft this piece of legislation. Circumstances and conditions: the circumstances under which the law operates, when properly expressed, adds to the clarity and precision of the law. E.g., Section 42 of the Penal Code Act, Laws of Uganda, provides as follows: when any person is convicted of printing a seditious publication, the court may, in addition to any other penalty imposed, order the printing machine on which the publication was printed to be confiscated for a period not exceeding 1 year, whether or not the person convicted is the owner of the machine or not. Shall and may: the basic principle in the use of the words shall and may in a legislative sentence is that shall imposes a duty or an obligation. Such shall is mandatory, whereas may is not. So what you have to understand is that when the legislation uses shall, it basically means that that piece of legislation is mandatory, but may, it's optional. Numbering of provisions: an act of parliament is divided into sections. A section should contain one idea and therefore one enactment. It should be self-explanatory. It should be self-contained. The section should be lucid, short, and simple. There should be no ambiguity as to its meaning, or it will be difficult to read. So your legislation should be always in paragraphs, like the way you see the Penal Code Act. And those provisions must be numbered: section 46, section 50, like that. Paragraphs: where section or subsection is unduly long, it is better broken down into paragraphs. The device of paragraphs helps the readability of the sentence, and when appropriately used, avoids ambiguity. So summary: sections are numbered using Arabic numerals, e.g. 1, 2, 3, 4. Subsections are numbered with Arabic numericals in brackets. Example: the commissioner shall keep a record in the form that he determines, in which he shall record the name and address of a person to whom he grants a license, and any dealing with or affecting a license has granted. So basically, that's how you do legislative drafting. Drafting of penal provisions. Laws are commands in the main. A command demands obedience. Obedience to the law is secured by sanctions. Sanctions are the penalties attached to disobedience to the law's command. An enactment would thus contain a penal provisions to ensure its compliance. In Ryle versus Hilde, the court held that the tribunal should endeavor to find out what, according to the well-known rules and principles of construction, the statute means, and if the meaning be clear to apply it in that sense, should be statute and ambiguous. So basically, the principle of drafting penal provisions, like the way we looked at under Article 28, that there must be a principle of legality. Article 28, I think 7, there must be a principle of legality. and principle of legality, we see that the offense must establish the ingredients as well as the punishment. So basically, that's what you have to have in mind when you are drafting penal provisions. And always these things don't always miss in the final exams. They tell you to redraft these penal provisions, and that's basically what you have to follow: paragraphs, numbering sections, as well as the principle of legality. So there are three elements: the element of prohibition, the contravention of the prohibition, and the sanction. That's the penalty of the contraventions. So basically, that's what is always contained in the penal provision. One, the element of prohibition. What does the penal code prohibit? Then secondly, the sanction, like the penalty if one contravenes, and also elements of the prohibition. What should you not do? Example: a person who files a false return commits an offense and is liable on conviction to a fine of 10,000 shillings. The above provisions implies the prohibition: a person shall not file a false returns, or no person shall file a false returns. B, a contravention of the prohibition: the filing of false return when the command is not file a false return. The sanction is liable on conviction to fine of 10,000. So basically, that's how you go about drafting penal provisions. The phrase "shall be guilty" is wrong. The Constitution in the most Commonwealth countries provides for presumption of innocence, so that basically means that the legislature simply states what is prohibited, and it is the court to determine whether the accused is guilty depending on the evidence adduced. So the language of registration. So have looked at basically penal provisions. You have to consider, have in mind the principle of legality. What are you prohibiting? The elements of the offense as well as the punishment. And don't please understand those things. You look at your penal code act, how it's drafted, because you might be required to draft those things. The language of registration. There is no special language, grammar, or composition for statutes. Dry just said, if the draftsman entertains the notion that he must make the statute sound legal, that is, he must employ expressions such as aforesaid, hereinafter, at every opportunity, that he must receive his nouns with such said, or that said whenever he can, that he must search for the longest word he can find and couple it with synonyms or two, that he must add a provided further and a provision always to each section, and that each sentence must be attached. So I don't clearly see what he's trying to explain here, but what is important to understand is that in language legislation, the word must be clear, straightforward, and easy to be understood, because you have in mind your audience to consider when drafting the legislation. One, we have the public, the court and lawyers, as well as the parliament. Then typography. Typography deals with the layout of the context. It is the visual component of the written word. It encompasses all considerations about the appearances of the typed visual script or text, which is a sequence of words, what space is left within words, and what space is left within lines. So basically, that's what we call typography, as in how are you going to space your legislation. Why is typography important? It helps to conserve the most valuable resources you have, that is your reader's attention. Never assume that the reader has unlimited attention for you. And good typography is for all professions. Good typography begins with good typing, and every character you use is a tool. Know when and how to use punctuation. So basically, that's what we call typography, a combination of your spacing and footnotes and all that kind of things. Spaces between sentences and punctuations, you should always put exactly one space between sentence words. Paragraphs marks are used when citing documents with consequential marks. Hyphens and dashes, they look the same, but they are different and serve different purposes. Dashes They come in two sizes, the M and N dash. Third, it's a typographical shorthand for the word. It should be used sparingly in text. It should be used where they are part of proper name, e.g. Chensia and Fitford. Then signature line, it's the horizontal line, a line which the parties must sign trademarks and copyright symbols, ellipses and apostrophe, word spaces, mass text symbols, page layout, line lengths, and also page margins. Punctuation in legislations, I have to consider things like full stop. Where do you put the full stop at the end of the sentence? Inverted commas in legislation, we always have inverted commas are used to define a word or a set of words in a textual amendment. And then also have brackets. The brackets are used in order to insert a paraphrase in information or an explanation into a sentence. The colon is used to make a formal introduction. It is used to indicate a serious or a punctualization or a list. Then the comma is used mainly in ordinary writing to cause a break. Then the semicolon is used in registration as a link between ideas, specifically in the enumeration of paragraphs or subparagraphs of a tabular nature. So we have examples here where these ones are used, but basically you have to understand these things. Like we have said, we always bring these things in the final exams. How do you redraft the following sentence? So they expect you to consider all these things, the full stop, the paragraph, semicolon, among others. Style and gender in drafting legislation. Legislation should treat men and women equally, and gender neutral legislation should become the norm. The following are some of the techniques that may be used. 1. Repeat the nouns in the place of a pronoun. An employer or factory shall take reasonable care to ensure the employer's own health and safety at work. 2. Use his or her instead of his. So basically don't have to be gender sensitive. Those things of saying that his refers to men and women no longer apply. Recast the sentence using the plural form. Then recast the sentence using a relative clause. A person who has lodged a memorandum of appeal may. Not if a person has lodged a memorandum of appeal, he may. Recast the sentence using a participle. A person shall give 7 days notice before lodging an appeal. Avoid demeaning or patronizing language. Basically, that was it, how you do legal drafting. Then look at letter and memorandum writing. You consider purpose, audience, as well as evidence. Purpose: what is the purpose of writing a letter or any other document? To inform, to persuade, and to engage. So the three may occur at the same time if they may operate at different times, but keep your language polished and respectful. Purpose determines the format of your letter. Is there a law that covers the format you are supposed to take? And the purpose also determines the facts. So you have to consider your audience, know your audience, the consumer of the document, the evidence, which evidence do you have, the significance, what's the importance of the writing, the style, what's the style used in your institution, and also the letters. So we also have an ordinary letter here with the heading, reference, date, Director of Public LDC, application for clerkship, like that. So it must have the date, the address, the salutation or greeting, title, content, body, close off, then font, Basically, that's what we expect in a letter. Then a memo is for internal use within the company. And where you are resigning, don't use a memo. It's a matter concerning you and not the firm. So a memo is an internal communication. So memos must have a clear purpose, essential information. It must be short text. It must state board actions, and it must state the action required. How is it formatted? A memo is written on plain paper, office memo, depending on the subject matter. There is no solution. The author signs against his or her title. The first paragraph is important to introduce the subject and expound form. So we have the internal memo here to professional assistants, carbon copy LDC, subject teaching allowance. This is the form that with effect from. So basically, that's a teaching memo. Then the rules minute. Rules minute is also written on plain paper. It is for internal use. It's an informal office communication. It is usually between two offices. Beyond that, you use a memo. So a rules minute is basically for two offices. They also have notices and demand letters. Notes to intended defendant. This is a notice of intention to sue. Then also have communication can also be by email. So email must also be brief and straightforward, precise and concise. Attendance notes. It may be presented by the firm, but you can generate one on a pen paper. Then also have what we call legal opinion and legal memorandum. So we have to look at your tone. Tone is the writer's voice in a letter, or maybe legal memorandum. So when you're writing for lawyers, that means you have to have a legal tone. Audience, you must also consider your audience, who you are writing to. Evidence, it is of paramount importance when writing a legal opinion. You ought to show that you are writing the truth, present it objectively, and support it with authorities. So basically, that's what we looked at: evidence, audience. Customize your tone and language to your audience. Are they professionals in the field you are writing about, or they are ordinary people? Tone is the writer's voice in the letter, memo, opinion, or other writing. Drafting legal opinion. Know the purpose, audience, evidence, and read critically. Question the credibility of the source of your evidence. Use proper rule, don't cite repeat rule. Write critically. Use terms. Define the terms used in legal memorandum or opinion. And then purpose of the legal opinion. Is it to inform, to persuade, or to entertain? Then we are looking at the art of thinking. You must think. Why are you writing? Who is your audience? What's the legal importance? You may be tasked to write a legal profession. So you give people findings to generate their thinking. Don't impose your opinions on them. Questions of purpose, questions of information, questions of interpretation, questions of assumptions, questions of implication, questions of point of view, questions of relevance, questions of accuracy, questions of precision, questions of consistency, questions of logic, and dead questions. So drafting transaction documents. So we talk about transaction documents, we mean sales agreement, mortgage deeds, car purchases, alongside others. So the first question you ask is, which area of law are you dealing with? Drafting before or after a transaction. Have knowledge on the areas of the law. Do some reading. And be familiar with the silent provisions of that transaction document. Purpose. Master the art of drafting transaction documents. Analyze transaction documents, managing transaction rights, understand the role of transaction lawyers, understand and appreciate clients, then write draft or transaction documents in plain English. Be familiar with context provisions like recitals, attestations, representation, warranties, conditions, general clauses, as well as miscellaneous etc. So basically, these ones we looked at in some other subjects. We drafted contracts, we drafted leases, we drafted contracts, sale of goods contracts. So those are some of the documents they expect you to understand. So you have to first plan the document. You ought to be familiar with the area of the law where you are operating. Framework of planning, work out what client or parties want in relation to each of them. Legal requirements, have a checklist of all the legal requirements and use it when conducting the transaction. Change of circumstances, visualize even 100 years ahead. Drafting, the heading should be connected to the document. Formatting the document, your document should have an introduction if necessary. Table of contents, especially for lengthy documents. Have a table of abbreviation if necessary. Provide a table of all the names and parties. Layout and topography. Layout here refers to the design, plan, or arrangement of the documents. Topography is the visual components of the written word. So basically that was it as far as legal writing is concerned. Here in drafting documents, they can bring to draft a sales agreement for the car, the land agreement, sale of land agreement. It could be a contract, sale of goods contract. It could be a lease agreement. Those documents we looked at in land transactions, in corporate and commercial, among others. So they can task you to draft any document in a legal writing under this part of a transactional document. So basically we looked at transactional documents, we looked at legislative drafting, we looked at writing letters, opinions, memos, loose minutes, and we looked at basically the art of writing. So basically that was it for legal writing. I believe that if you can go through this document, then it shall be good to go. So in case you want this document, it's a document by His Excellency Riora. His Excellency Riora. He says that by making mistakes, I learned not to make mistakes. Ignatius de Loyola, MDG, Magis. I hope he doesn't sue me for copyright, but he's a very good guy, very good counsel. One of my friends, I know him very well. But in case you want this document, please text me. I will send it to you in your inbox in case you don't have it. But these are legal writing notes by son of Riora. He has been one of the most helpful colleagues that has blessed the legal profession. So in case you don't have this document, you can text me and I will forward it to you. And I think that's it for all I had for you today. I wish you success in your exams. You can do it. Don't be put down by the few marks you have. Losing the battle doesn't mean that you're going to lose the war. You can do it. I believe in you. Please, I wish you success in your category B exams. Please subscribe, like, share, and comment, and turn on that notification button as we shall continue with notifications up to the end of the year. We remain the pass bar team.